If you've been involved in a car accident that has led to a lawsuit, there's a good chance you will be asked to participate in something called a deposition. For many people, this is unfamiliar territory, and it can seem intimidating. But knowing what to expect can make a huge difference in how you approach the process and how confident you feel. In this video, we're going to go step by step through what a car accident deposition is, why it happens, what kinds of questions you can expect, how you should answer them, and some tips for making the best possible impression. Let's start with the basics. A deposition is essentially a formal interview conducted under oath. It's part of what lawyers call the discovery phase of a lawsuit. This is the stage where both sides gather information, exchange evidence, and try to understand the facts before the case goes to trial. In a deposition, you will be asked a series of questions by the opposing attorney, and everything you say will be recorded by a court reporter or sometimes by video. You are sworn in, meaning you are legally required to tell the truth, just as you would if you were testifying in a courtroom. Unlike a trial, a deposition doesn't happen in front of a judge or jury. It usually takes place in an attorney's office or a conference room. The people present will normally be you, your attorney, the opposing attorney, the court reporter, and sometimes the other party to the lawsuit. The setting is more relaxed than a courtroom, but don't mistake that for casual. Everything you say is part of the official record and can be used later during trial or settlement negotiations. The main purpose of a deposition is to allow the lawyers to gather testimony in advance. The opposing attorney will be trying to learn exactly what happened, evaluate your credibility, and see how you might appear as a witness in front of a jury. Your own attorney uses the deposition as a way to prepare for trial, understand the other side's arguments, and potentially find areas of strength in your case. Before the deposition takes place, your lawyer will likely schedule a meeting with you to prepare. In that meeting, they'll go over the facts of your case, review your statements, and talk about the kinds of questions you might be asked. They'll remind you of a few key rules. First, always tell the truth. Second, only answer the question you're asked. Third, don't guess. If you don't know the answer, it's fine to say you don't know or you don't recall. Fourth, take your time. You don't have to answer instantly. Pause, think, and then respond. On the day of the deposition, it usually begins with some simple background questions. These might include your name, address, date of birth, educational background, work history, and basic personal details. This isn't meant to trip you up. It's just a way for the lawyer to get general information on the record. From there, the questions will shift toward the accident itself. Expect to be asked about the date, time, and location of the crash. You might be asked about the weather and lighting conditions, the traffic, the speed limit, and how fast you were going. The attorney will want you to describe in detail the moments leading up to the accident. What you saw, what you heard, and what you did. They may ask whether you were using your phone, adjusting the radio, talking to passengers, or otherwise distracted. You may also be asked about whether you were wearing your seatbelt, whether you had consumed alcohol, or whether anything was obstructing your view. They'll likely ask about your interactions with the other driver. Did you speak to them before or after the accident? What did they say to you? Did they admit fault? Did you exchange insurance information? Were there any witnesses at the scene? And what did they say or do? These details can be very important later in the case. A significant portion of the deposition will probably focus on your injuries. You will be asked to describe them in detail. When you first noticed them, what symptoms you experienced, and how they have changed over time. You'll be asked what doctors you've seen, what treatments you've undergone, and whether you've needed surgery, physical therapy, or medication. They might also ask how your injuries have affected your daily life. Can you still work the same hours? Can you do household chores? Has your ability to enjoy hobbies or spend time with your family been reduced? These questions help them understand not only the physical, but also the emotional and financial impact of the accident. You should also be prepared for questions about your medical history. The opposing lawyer may ask whether you've had any previous injuries or health conditions, even if they seem unrelated to the accident. This is to see if they can argue that your current symptoms might be from something other than the crash. During the deposition, the opposing attorney may ask the same question in different ways, sometimes hours apart. This is not necessarily to trick you, but to see if your answers are consistent. If your story changes, even slightly, they may try to use that later to challenge your credibility. That's why it's so important to stay calm, stick to the facts, and not let yourself be rushed. Remember, your lawyer is there with you the entire time. If a question is unclear, you can ask for it to be repeated or rephrased. If a question is improper, your attorney may object. Most of the time, you will still answer the question, but if your lawyer tells you not to, you should follow their instruction. Depositions can be long. They might take a couple of hours or even most of the day. You are allowed to take breaks. If you feel tired, need to use the restroom, or want to speak privately with your attorney, you can ask for a break. It's better to pause and collect your thoughts than to give a rushed answer you later regret. Here are some tips that can help you handle a deposition successfully. First, listen carefully to each question before answering. Don't interrupt. Second, keep your answer short and factual. Avoid giving extra information that wasn't asked for. Third, don't speculate or guess. Only speak about what you personally know or remember. Fourth, remain calm and polite, even if the questions seem repetitive or challenging. The opposing attorney may be observing not just your answers, but your demeanor. Also, be mindful of your body language. Even though this isn't in front of a jury, the other side is still evaluating you. Slouching, fidgeting, or appearing irritated can give a negative impression. Sitting up straight, making eye contact, and speaking clearly can help you appear confident and credible. After the deposition, the court reporter will prepare a transcript of everything that was said. You may have the chance to review it and correct any errors. Your lawyer will study the transcript carefully, using it to plan your case strategy and prepare for trial or settlement discussions. In summary, a car accident deposition is not something to fear if you are well prepared. It's a formal but straightforward process designed to gather information. By working closely with your attorney, understanding the types of questions you'll face, and following the basic principles of truthfulness, clarity, and composure, you can navigate your deposition with confidence. Remember, the deposition is your opportunity to tell your side of the story, and the better prepared you are, the stronger your case will be.